Okay.
Okay, good afternoon, ladies and gentlemen. Welcome to virtual County Court at Law number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. It is approximately, 2:45 p.m. on Monday, November 2nd, 2020. We have 9 either motions to revoke community supervision or motions to enter adjudication of guilt and revoke community supervision hearings set for the day. Representing the state in all hearings will be Mr. Nicholas Maru. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. At this time, let's start with Mr. Vasquez's client, Ms. Brianna Gonzalez. My understanding is the state and the defense have entered into an agreement. Is that correct?
We have an agreement, Judge.
Let me formally announce what's going on. This is case number 575147, state of Texas versus Brianna Gonzalez. This is currently a motion to revoke community supervision. It's my understanding that since this motion has been filed, Ms. Gonzalez has actually completed some of the things she was alleged not to have completed, and due, I'm sure, to her crafty defense counsel getting in there and getting her guy on the right path. And it's my understanding the state is making a motion to withdraw this motion to revoke probation. Is that correct?
Yes, Judge, and terminate unsatisfactory.
All right. Defense, any objection to that?
No objection.
Ms. Gross, any objection?
No, Your Honor.
All right, that will be granted. So
Thank you.
Ms. Gonzalez, probation is hereby terminated as unsatisfactory. Good luck, Ms. Gonzalez. Thank you, Mr. Vasquez.
Thank you, Judge. Thank you, Judge.
Thank you.
Okay, the next one I have is Mr. Gary Zaborowski, represented by Mr. Floyd Lamrou. Are they here today?
Yes.
Okay, Mr. Lamrou, am I pronouncing your name correctly? Your microphone is not turned on, Mr. Lamrou.
Can you hear me now, Your Honor?
Yep, got you. Correctly, sir?
Yeah, I was actually going to say that my name is Lamrouet, but we anglicized it as Lamro, and I was terribly wrong with Mr. Marou's name, thinking it was French, and it's not. So anyway, Your Honor, I have spoken with Ms. Gross and Mr. Marou, and a capias bond was issued that I was not aware of, and I cannot find in the records of the court that there was supposed to be restitution of $23,000. I was not aware of that, and that's my responsibility. But if Your Honor could give me a 7-day continuance so that I can investigate that capias, because the documentation I see is a $4,000 fine, theft for $500 to $1,500, and then court costs of $344. The capias shows 80 hours community service plus restitution of $23,000, and I imagine that with that facing the judge that Your Honor would remand him to Bexar County Jail. So if you would give me 7 days to examine the situation.
Let's discuss that very briefly. For the record, we're talking about cause number 263955, State of Texas versus Gary Zaborowski. And this is a motion to
revoke probation, Your Honor.
And the only allegation on this is that Mr. Zaborowski allegedly did not initially report to the Supervision and Corrections Department for orientation after he entered a plea on this case. State, is that your understanding of the allegation?
Yes, Judge. The defendant has been AWOL for over 10 years.
Okay, and Ms. Gross, is that your understanding of the allegation?
Yes, Your Honor. He failed to show up at probation to sign his initial conditions.
Mr. Lamrouet, would that be good?
The Lamro is what it's anglicized to, Your Honor.
Would that be your understanding of the allegation against your client?
At this point, yes, Your Honor.
For purposes of settlement negotiation, before we actually get into an MTR and or I rule on your request for continuance, is there any chance that Mr. Zaborowski can pay this $23,323.66 that he allegedly owes?
Okay,
Mr.
a little bit, long story, try to shorten it. For 10 years, Mr. Zabrowski has been employed as a waiter, sometimes holding down 2 jobs. 2 weeks ago, he acquired a well-paying job with a company that works with Toyota. That will allow him to make restitution payments, something he couldn't have done before. And I think the state, this is my opinion, Your Honor, I think the state would be well served to receive the $23,000 in restitution than to put Mr. Zabrowski in jail for a year, destroy his family, take away his job. And I think the state would rather have the money than have to pay for Mr. Zabrowski being in jail for a year. But that's just my opinion, Your Honor.
Well, let me go back to my initial question. Is there any chance Mr. Zabrowski can pay restitution on this case at this time?
Not full restitution, no, Your Honor.
Is there any amount of money that Mr. Zabrowski can pay on this debt at this time?
He's been paying down his bonds. And as I said, this job just started 2 weeks ago, Your Honor. So I would imagine there is maybe a couple $100, but that's a pittance, Your Honor. I understand that.
Okay. With regard to your request for a continuance, I don't really have a problem with that. I just don't really think anything's going to change between now and then. We've got an incredible amount of money that apparently Mr. Zabrowski legally owes, and he's not been able to pay. And all this came about because of, I guess, hot checks that he wrote. And on this particular case, and state, correct me if I'm wrong, probably all these different amounts of money were added up probably from other cases and just consolidated on this one case. Does that sound right?
That's correct, Judge.
That's what we assume, yes, Your Honor. Your Honor, I asked for 1 week because that may give us some time to contact family, friends, whomever, and at least make some sort of payment that is acceptable to the court.
I'm going to grant your motion for continuance. My perception, and I just, I read the document that you sent me, which we're going to call for purposes of the record Exhibit A. And I think you indicated you'd already talked to Mr. Maru about it and sent a copy to him and sent a copy to Ms. Gross before you ever sent one to me and got Mr. Maru's permission to do that. Is that correct, Mr. Maru?
That's correct, Judge.
So I'm familiar with that document. And for future purposes of this hearing continuing, we're going to go ahead and admit it if that's what you'd like to do as Defense Exhibit A for identification now, admitted into evidence as Defense Exhibit A. And I'm kind of between a rock and a hard place, as is Mr. Zabrowski, because, I'm in a position, if the restitution were paid, obviously everybody would be happy and Mr. Zabrowski could go his merry way and there would be no further proceedings if I were guessing. State, if there was full restitution, I assume you'd be willing to withdraw this MTR. Would that be correct?
That is correct, Judge.
Okay.
Judge, if I may,
Sure.
in addition to this case is so old, there are only 2 options that we have, and that would be the revocation or term unsat. And then additionally, it's not on the motion to revoke because of the age of the MTR, but the defendant has been arrested and charged with a new theft in Houston. Now, the attorney says that it's going to be worked out, but still, the court needs to be aware that there is a new case in Houston.
Yes, Your Honor, that is correct.
Understand.
Your Honor, may I speak?
And speaking with the attorney, the court-appointed attorney, there's really no evidence either way, and she's fairly confident that it'll be dismissed. But I understand that getting another charge against him is just one more charge against his MTR here in San Antonio, one more violation. So,
Well, it's not been alleged, and we're not going to consider that. I thank the defendant and his attorney for bringing that to our attention, not trying to hide the ball. But I think Mr. Zabrowski wanted to speak if his attorney will let him do so. Is that correct, Mr. Zabrowski?
You're muted. Can't hear you. Nope.
Hello?
We
Yeah.
can barely.
Mr. Zaborowski. And with your attorney's permission, you're welcome to make a statement.
Mr.
Okay, can you hear me?
Yes, may I
Yes.
address him, Your Honor, before he makes a statement? Mr. Zaborowski, have you heard the discussion between me and the judge and ADA and Ms. Gross?
Yes,
Are you aware that there's a $23,000 restitution in place
yes,
required? And are you going to address that to the judge?
yes.
Your intent? Okay. I have no objections, Your Honor.
Thank you. Go ahead, Mr. Zaborowski.
Okay, Your Honor, just my statement is 10 years ago when I went ahead and signed for the probation, there were several factors that, including my ex-wife had left me, taking my children, and I hadn't seen my children in over a year. She had left with them. And so I was distraught with, not being able to see them, as well as losing my business, which I had with her at the time. I lost my home. I was homeless, living out of the Salvation Army in Houston. All these factors came together in me not being able to complete my probation. Now I'm remarried. I have a home. I have a job at the Toyota plant. And I have the ability and the capability of repaying back not just, the fines, but the restitution. Given the chance to, I think it'd be better off for everybody if I went ahead and paid back the restitution, and been able to work for Toyota instead of being in jail for a whole year, which would probably, destroy my family and my opportunity for employment after the fact.
State, is this a Class A or a Class B?
Second, Judge.
It's, Your Honor, it's a 500 to 1,500.
It's a Class A, Judge.
Gotcha. Once again, I'm kind of between a rock and a hard place on Mr. Zaborowski's circumstances, and we understand that you went through a hard time and that hopefully that's going to be in the past and you're coming out of it, but that doesn't really help these people that are out $23,323.66. So that's kind of where the state, if I were guessing, and the probation department are coming from with regard to getting them reimbursed.
One more interjection from me, Your Honor, if you don't mind, if I interrupt you for a minute.
You bet. Go ahead.
Again, I asked for at least a 7-day continuance. That may provide us an opportunity to find a substantial amount of money to make a payment against that restitution. And that's my only purpose for requesting that 7-day continuance.
Problem. Once again, that'll be granted. Get with Ms. Benavides, and in the next 7 or 10 days, Pat, during one of our normal MTR hearings, reset this for them. And,
Yes, Your Honor.
And
Yes,
we'll
Your Honor.
go with that. No problem. Anything further we need to chat about at this time, State?
No.
What would be the minimum?
Go ahead.
Mr. Gary, Mr.
Yeah, I was just wondering what the minimum would be accepted, if I could come up with some money.
I don't have an amount in mind. Obviously the most you can get is what the state would want. I think it's probably far-fetched to think you can come up with the entire amount, but that would be a wonderful thing if you could. And that's the amount that technically you owe these victims that you took their money. So that's what you're shooting for. And then whatever you actually get to less than that, we'll be all happy to talk about at that time. But we're going to be happy to give you the 7 or 10 days, whatever you need to see if you can find anybody that's going to lend you that amount of money or would help you in some way. Fair enough?
Thank you, Your Honor.
Any further questions from the state or the defense on Mr. Zaborowski's case?
No, Your Honor, can I be excused?
You bet. Just get with Ms. Benavides and she'll reset you for 7 or 10 days, whatever's best for y'all.
Mr. Lambro, I will get with you. I will send you a new date. Okay?
Thank you, Ms. Benavides. Appreciate
You're
all your
welcome.
help. Again, thank you, Your Honor. May I be excused?
Thanks, guys.
Yes.
Next person on my list is Mr. Frank Besa, and I believe Ms. Kramer had to go to a different court. I don't know if she's back yet or not.
Yes.
Is she back?
No.
I don't think so, Judge.
Mr. Besa, are you on today? Are you still with us today?
I don't see him, Judge.
We'll come back to them.
Mr. Baines is in a breakout room and
Right.
Dan is ready. So I would go with the others until she comes in.
All right, let's take up Mr. Geddes, cause number 618046, State of Texas versus Cameron Geddes. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Mr. Geddes is Mr. Flavio Hernandez. And once again, representing the state is Mr. Nicholas Maru, and representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. This is an uncontested motion to revoke probation, is my understanding. How does the defendant plead on this motion to enter adjudication of guilt?
He's going to plead true to violating the conditions of probation. I believe the state was going to make a recommendation.
Okay. Ms. Gross, would you please advise all parties what the status of Mr. Geddes' probation is at this time?
Yes, sir. This is Mr. Gettes's fourth violation report, resulting in his second motion to revoke. He has very poor reporting in that he only ever reported one time, which was on February 24th of 2020. He has made no effort to make any payments, has a balance of $1,327 and is delinquent $1,277. He has not completed any of his 48 hours of community service, nor has he provided proof of enrollment or completion of the stress class. He left Bexar County without the permission of the court. He was arrested and charged with 2 new criminal offenses, which was manufacturing and delivery of a controlled substance, penalty group 2, and endangering a child. He failed to report this arrest to his officer, and the probation department is recommending that he be revoked. For a criminal history, he is on probation for this case, the unlawful carrying of a weapon in a motor vehicle. He has a prior arrest for possession of a controlled substance, penalty group 3, less than 28 grams. Possession of a controlled substance, penalty group 2, less than 1 gram, and failure to report highway damage.
All right, I went out of order on this. I apologize to all parties, but let's go back and go over a couple of documents that the defense counsel and the defendant signed for this particular hearing. One is entitled Defendant's Consent to MTR Hearing by Video Conference, and it is allegedly signed by both Mr. Geddes and Mr. Hernandez. Mr. Geddes, is this your signature on this document, sir?
Yes, sir, it is.
Mr. Hernandez, will this be your signature, sir, on this document?
Yes.
Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And I noticed that on my copy, where it says at the top in the style of the case and the county court at law number, and 6 is not in there, so that needs to be placed in there. Otherwise, it seems to be executed correctly. This document also appears to have consent of both Mr. Geddes and attorney Mr. Hernandez. Mr. Geddes, is this your signature on this document, sir?
Yeah, yes, sir, it is.
Mr. Hernandez, will this be your signature on this document?
Yes, Your Honor.
State, what is your recommendation on Mr. Geddes' case?
Judge, the state would recommend, speaking with his attorney and looking at the fact that he still needs to answer for these pending cases in Guadalupe County, I believe, that I believe he is not currently on deferred. If you would revoke and place him on regular probation so that he can still be supervised during this period while he figures out his felony cases in Guadalupe.
I guess my concern to that is the fact that we haven't seen him for so long. I don't get a warm, fuzzy feeling he's going to do anything more for us now than he did before. Defense, what can you tell me about that question?
Your Honor, this has been a very trying times for everybody. I think that the last 6-7 months has been crazy. Everybody's afraid of dying. Nobody wants to hire anybody. Everybody's running for their lives, trying to stay alive these days, Your Honor. Mr. Geddes has been a free man basically for 11 months, Your Honor. He is not a dope addict or a dope dealer or a dope manufacturer. He ended up in the company of some people that were involved with drugs and had a child with them. he did not have a child with himself. These felony charges, I think, I'm very optimistic that he's going to be able to get off, fight these charges. But he won't be able to do that if he's locked up in Bexar County Jail. He's only 20 years old, Your Honor. I don't want to throw his life away for a misdemeanor probation violation. If you put him on regular probation, he's ready to grow up and take responsibility and adapt himself to our situation today. The limited employment, the limited opportunities there are for him to be a regular citizen.
Yes, sir.
He's not done well, but he's not done horrible, Your Honor. If he had done something horrible or proven that he's done something horrible, he would not be a free man today. He's
Does Mr. Gaddis have an actual job at this time?
You said, do I have an actual job at this time?
Yes, sir.
I actually do, but due to my ankle monitor, I'm not able to work.
He has contacted me prior to this hearing, Your Honor. He was requesting relief regarding the ankle monitor. This is something that he has already approached me about prior to this hearing.
And did Mr. Gaddis previously in this hearing plead true to all these allegations? Is that correct?
I'm not sure that he's pled true, but he's willing to plead true to whatever the state is requiring.
Obviously, he doesn't want to plead true to these new allegations, new cases out of county. So he's pleading not true to those, I'm guessing.
That he's been arrested, he'll plead true, but not that he's guilty. No, he's not.
No. You're not going to want to plead guilty to those.
Judge,
Yeah.
if I may,
Sure.
being that this is the defendant's second shot or second motion to revoke, I'd just like to remind the court that the original motion to revoke was filed because he did not show up to probation to sign his paperwork. Therefore, probation has no faith in this defendant that he is going to comply at this time, and we are standing by our recommendation that the defendant be revoked and not be placed on probation.
Your Honor, that is a true statement, and I think the court can view it in a more positive light. His first MTR, if you want to call it that, was not based on any violations, any new arrest, any failures to attend classes, failures to pay money, anything else that is a typical basis for an MTR. It was simply that he did not end up at the orientation when he was supposed to. I don't believe that is an egregious offense, and I believe the court did the right thing to let him keep his probation. Today, we want to surrender the deferred probation and ask for regular probation.
And once again, Mr. Hernandez, and I apologize for going over this again, but am I correct in assuming the defendant is pleading true with an explanation to every allegation on this MTR except the two new number ones, which I assume we can call 1A and 1B on this particular motion to enter adjudication of guilt?
Yes, Your Honor. I believe that is correct.
Okay. Mr. Gaddis, the court accepts your plea of true to all allegations on the motion to to enter adjudication of guilt and revoke community supervision except 1A and 1B alleging the two new offenses out of county. I grant the state's motion to revoke your deferred adjudication probation. I find you guilty of the offense of unlawfully carrying a weapon. I sentence you to 1 year in the Bexar County Jail, assess a $4,000 fine plus court costs, credit for time served, time and money to run concurrent. If Mr. Gaddis can get a job, I'll grant him work release, but I don't know that he has an actual job that's going to that right now.
I do, sir.
You do? All right. You can take that up with the work release folks, but I'll be happy to give him work release, and that's going to be the chance he gets. It's just too aggravated otherwise to give him any other ability. He's had plenty of opportunities to do well, and it hasn't worked out for him. So I'm sorry it's that way, but it's that way. So good luck, Mr.
Excuse me, sir.
Sir, I want you to turn yourself in to the Bexar County Jail Work Release Program this coming Monday morning. Give you some time to get your affairs in order at 9:00 a.m. So that's going to be Monday, November 9th, is it not, Pat?
Yes, Your Honor.
Okay. You understand that, Mr. Gaddis?
Yes, sir. And can I say something?
Attorney's permission, absolutely.
The reason why it was so hard for me to like do things is because I just moved down here from Mississippi, sir, and it was kind of hard like adapting here in Texas. Like it's no excuse, and I do take responsibility for what I did and not going to handle my business like I was supposed to. But sir, I'm trying to grow up, sir. I don't want to be in jail, sir. I had my firstborn while I was locked up this past time in Seguin when I had to sit for the 90 days indictment. And sir, I just want to get out and do right, sir.
Mr. Hernandez,
I understand.
do you represent Mr. Geddes on the two cases out of county also?
No, Your Honor, I do not.
Okay, well, I don't know if you want to find out whoever that is, but this might be a time for them to try to work those out and utilize this time as a CC type circumstance to save him, future problems.
Yes, sir.
Any further questions, Mr. Geddes?
No, sir.
All right, best of luck to you. Thank you, Mr. Hernandez.
Thank you, Judge. See you.
Okay, my next case is cause number 628-357, State of Texas versus Rodney Taylor with Mr. Garcia, the attorney. And we got Mr. Garcia and we got Mr. Taylor somewhere. Mr. Taylor, you today? Oh, I got you. Yeah, I see you. We're all good.
Do I just hang up, Judge?
You're good. We can hear you. You're fine. All right. Let me start off by saying I have two documents for y'all to identify. One is entitled Defendant's Consent to a Motion to Revoke Hearing by Video Conference, which purports to have your signatures by both Mr. Taylor and Mr. Garcia. Mr. Taylor, is this on this document, sir?
Sorry, it broke out for a second. I couldn't hear what you said.
I'll restate it. Mr. Taylor, I have a document entitled Defendant's Consent to MTR Hearing by Video Conference that purports to have your signature on it and your attorney, Mr. Garcia's signature on it. Is this your signature on this document, sir?
Yes, sir.
And Mr. Garcia, would this be your signature on this document?
It is, Your Honor.
Thank you. And then I have a second document entitled Trial Court Certification of Defendant's Right of Appeal, which also purports to have each of your signatures. Is this your signature on this document, Mr. Taylor?
Yes, sir.
And is this your signature on this document, Mr. Garcia?
It is, Your Honor.
Thank you. Now I'm looking at a motion to enter adjudication of guilt and revoke community supervision. In this case, as in all cases heard today, representing the state as Assistant Criminal District Attorney is Mr. Nicholas Maru. Representing the Bexar County CSCD is Ms. Susan Gross, who our mind is still under oath. On the motion to enter adjudication of guilt and revoke community supervision, how does Mr. Taylor plead?
He's going to plead true, Your Honor.
And Ms. Gross, would you please advise all the parties what the status of Mr. Taylor's probation is, please?
Yes, Your Honor. This is the defendant's sixth violation report resulting in the first motion to revoke. His reporting has been very poor. We have not seen him since May 27th of 2020. His case is paid in full. We have no proof of completion of any of his 36 hours of community service. He has one positive drug test for marijuana. He failed to submit to drug testing on one occasion. He has completed DWI education, victim impact panel, and CAT-SNP. On his last violation report, the court was gracious enough to allow him not to have a warrant issued via a motion to revoke at that time, and you ordered him to get a scram device within 10 days. The defendant has not obtained a scram device. His officer is recommending that probation be extended a period of 6 months, that he obtain the scram device, and that he also have the drug offender education program added as a sanction of probation, and that he submit to weekly drug testing.
Actually, if I may, Judge,
Sure.
Just as an update, we're pleading true to condition number 5. He has had the scram installed. He has done the community service. He will be getting Ms. Gross proof of that. He paid off to a charity that I believe is one of the listed charities that is accepted. And so he has been working to get back in line. And as Ms. Gross said, he did do all the programs. And he did do a lot of the tests. He has made mistakes, but Judge, we're asking that you follow the agreement both by probation and by the state, who are recommending continued probation with the GPS and the dope course.
And state, go ahead and state your recommendation for the court or your agreement with the defense on this case.
It's along with probation, Judge.
And the reason we had to order Scram apparently was he missed 85 blows on a Smart Start mobile device. Would we all agree that that happened?
We do,
Yes,
Judge,
Judge.
but if you look at it, he missed 85, but he also passed, let's see, 150, 240, 410, 620. At the same time, he passed about 850 tests while he missed those tests. So it doesn't excuse the fact that he missed some of the tests on those days, but he did take them throughout the day, Judge.
And then Mr. Garcia, with regard to his failure to report, what was going on for those 2 months? Apparently 2 months plus or minus?
It was just
5.
condition number 5 is the months of June and July of this year, Judge. It's a weak excuse, Judge. I've explained this to him, that it's his probation. It's his duty to make sure he reports. He said he called down there. He got hold of a couple of people. Sometimes they didn't transfer him to the right people. I explained to him that it was his duty, especially after several prior violations, to get himself down there in person, to speak to the people, get their names, take their pictures, so that when he gets dragged before you, if he did, he could explain to you, I went down there, I spoke to these people, I still couldn't get where I needed to, Judge. He understands that this is his fault, Judge. He's not trying to excuse it, but as you heard from the prior attorneys, some of these people are running scared for their lives because of COVID. And on behalf of all of that, Judge, he doesn't owe $23,000 to the state.
Judge, if I may.
Go ahead, Susan.
His last report was May 27th of 2020. We haven't seen or heard from him, so he's missed a total of 5 months, even though only 2 are alleged.
All right, in a perfect world, if Mr. Taylor were allowed to finish probation, he comes off probation 27th or 26th, 2021. Would that be correct? So about 2 months or 3 months from now?
Yeah,
Yes,
it would be January 27th of 2021.
And Garcia, are you telling me he's willing to stay on Scram during those 3 month period of time?
He's willing to do whatever you want, Judge.
Is that correct, Mr. Taylor?
Yes, sir. If
Oh, good. All right, Ms. Taylor, and cause 628-357, the court accepts your plea of true to condition 5 with an explanation. On the motion to enter adjudication of guilt and revoke community supervision, I deny the state's motion to enter adjudication of guilt and revoke your community supervision. Order you continued on deferred adjudication and probation with all prior requirements and no sanction at this time. Although I have the authority to put you in jail for 30 days to get your attention. Do I need to get your attention that way?
no, sir, because I was arrested for a warrant for 3 days, and I also have a GPS monitor on me as well as the Scram device.
All right, good answer. And he's already on the Scram device, which I did not have knowledge of, so good to go on that. You're going to be required to stay on the Scram bracelet for the duration of your probation. Ms. Gross, is there anything else he needs to do to successfully complete probation except not drink?
We have no record of his community service, so if he's completed that, he needs to get those hours to his officer, and he needs to quit smoking marijuana. And so I don't know if you want to add weekly UAs to that as well.
If I test you, if I send you out for a UA today, Mr. Taylor, are you going to come up positive for marijuana?
I believe so, sir. Yes.
All right. Just depends. What do you mean? Mr. Taylor, go ahead and put him on weekly UAs with the understanding once he shows me 4 clean weekly UAs, we'll take him off of the weekly UA business.
All right. How about drug offender education?
He finished the Community Alliance for Traffic Safety New Intervention Program.
Yes, he's completed that. Do you want to add the dope class? Can't hear you.
Got everything else. So we're good, Mr. Taylor. No more hanging out with your buddies and smoking green leafy substances. No more drinking light beer from Miller. And do exactly what the attorney said do and you'll be good to go. Fair enough?
Fair enough. I only had one question.
Yes, sir.
About the GPS device. Would I still have to keep that on as well? Because I'm on a complete house arrest with this on.
Are you a GPS device right now?
Yes, sir. When I got arrested before I was leave, they put me on a GPS device.
We're going to waive your GPS as of right now. So within 24 hours, there'll be an order in letting you turn that back in.
Okay, thank you.
All good. Ms. Garcia, anything further on your side?
No, Judge, just if Ms. Gross would send Mr. Taylor her email address so that we at least have one contact within the probation department for Mr. Taylor to reach out to.
His probation officer will, Mr. Taylor, your officer is going to be sending you some paperwork within the next 24 hours for you to sign electronically. You need to sign that document and send it back immediately. And if you have any questions, then you can just call your officer, and it's on you. It's your responsibility. And Judge, one last question, because your mic was breaking up. Did you or did you not add a drug offender class?
Add DOEP.
Okay, thank you.
The only thing Mr. Taylor has to do to successfully complete probation, stay on scram without violations, 31 days from today, be clean from any future marijuana hits, finish the DOEP course, and I guess we're good to go. Does that sound right, Susan?
And weekly drug tests.
And weekly UAs until I get 4 clean UAs. Mr. Taylor, we're going to make sure you don't have a problem with probation. If you're back 24 hours, try one more time. If he or she still does not call you back, call your attorney. He'll call me directly, and I'll make sure that your probation officer gets back with you. Fair enough?
Yes, sir. I just don't have that phone number no more because I have broken and lost 2 phones since that time.
When the probation officer, do you have a phone right now?
Yes, sir.
Okay. We have that number so that the probation department can find you and call you in the next 48 hours?
Yes, sir.
Susan, we have that number?
I'm going to give him her number right now. It's 335-7473. Officer Salomon.
You want to write that down, Mr. Taylor?
Yes, if they could repeat it once more.
Sure.
Yes, 335-7473.
473.
Officer Salomon, Salomon.
He's
Okay,
the smart
thank you.
one. Solomon.
Are they going to call him or is he going to call them?
No, they're going to email him his paperwork to sign, but if he doesn't have it within 24 hours, he needs to call her.
Okay. Mr. Taylor, you had any more problems with anybody on your probation, get with your attorney, he'll get with me, and we'll get to the bottom of it immediately. Don't wait, okay?
Yes, sir.
All right, anything further from the state of the defense on Mr. Taylor's case?
No, just thank you, Judge, on behalf of my client.
Good luck, Mr. Taylor.
Okay, thank you.
Y'all have a great day.
You too.
Okay, next case I have is cause number 633105, State of Texas versus Christina Hicks, as represented by Mr. Cecil Bain. Once again, representing the state will be Assistant Criminal District Attorney Nick Maru. Representing the Bexar County CSCD is Ms. Susan Gross. Our mind is still under oath. On this case, I also bring to the attention of defense counsel, Mr. Bain and Ms. Hooks, that there are 2 documents I need identified. One is entitled Defendant's Consent to MTR Hearing by Video Conference. In fact, Ms. Hicks, is this your signature on this document, ma'am?
Yes.
Thank you. And Mr. Bain, would this be your signature on this document also, sir?
Yes, Your Honor.
Thank you. The next document I have in front of me is entitled Trial Court Certification of Defendant's Right of Appeal, also purportedly signed by Ms. Hicks and Mr. Bain. Is that your signature on this document, Ms. Hicks?
Yes.
And your signature on this document also, Mr. Bain?
Yes, Your Honor.
This is an uncontested motion to revoke probation, is my understanding, on the motion to enter adjudication of guilt and revoke community supervision. On the motion to enter adjudication of guilt and revoke community supervision, how does Ms. Hicks plead?
Your Honor, Ms. Hicks would like to explain to the court her emotional and financial difficulties and that she's only been working part-time since October and would like to explain to you why she'd like to be continued on probation, but she will be pleading true.
All right, we'll say true with an explanation so that she can clarify all that.
Yes, Your Honor.
Ms. Gross, would you please advise all the parties of the status of Ms. Hicks' probation currently?
Yes, Your Honor. This is her second violation report with a first MTR. Her reporting has been good, although she did fail to report last month. She has paid $320 towards her fees, has a balance of $906, and is delinquent $511. She has only completed 6.5 hours of her 36 hours of community service. She's had a positive drug test for marijuana, a diluted drug test, and a tainted drug test, in that the defendant was caught with a device trying to use someone else's urine. She's failed to enroll in or complete or provide any verification on the DWI Education Victim Impact Panel. And she has completed the CATSNP program. She is on Smart Start Mobile, supposed to be testing 6 times a day, but I show that she's been in lockout since September 23rd of 2020. She has no criminal history, but we are recommending that her probation be revoked.
Let me back up. I have an audio problem on this remote scenario on Zoom. Has she successfully completed the Community Alliance for Traffic Safety New Intervention Program?
Yes, that's the only thing.
She's completed.
When?
Is that correct?
You're breaking up. I'm sorry, Your Honor. I didn't hear you.
Done the Victim Impact Panel?
No, she has not done victim impact or DWI education. The only thing she's done is CATSNP and 6.5 hours of community service.
Okay. Did you have some mitigation that you wanted Ms. Hicks to testify about, or you wanted to bring to our attention?
I think she'd like to speak to you. Her difficulties have been both emotional and financial, and she's a 19-year-old and partially completed what she's supposed to do and wants to explain to you why she believes she can complete it at this time.
Okay, with your permission, Ms. Hicks, would you like to make a statement to us?
Yes.
Go ahead, ma'am.
I would just like to say that as far as the Smart Start, I didn't get permission to stop it, but I stopped because I did complete the 6 months and I did blow in it the 6 months. And at first, the only reason I did only six community service hours was because when I was making payments to probation, I was working over 40 hours a week, but I don't work as much now, which is why the payment stopped, but I was granted SSI, so I believe that I would be able to make all those payments back, and I do have the time to go complete my community service.
Are you currently working, ma'am?
Yes.
Where do you work?
It's called Prometric. It's a testing center.
Do you have any children at this time?
No, I do not.
State recommendation on Ms. Hicks?
I'm sorry?
I'm asking for the state's recommendation on Ms. Hicks' case.
Yes, Judge. The state's recommendation would be, considering this is her only case, she's at a very young age, and it doesn't seem to be too aggravated. Looks like she just has a problem smoking marijuana and things of that nature. She still has time to complete the things she needs to do. The state would recommend revoking her deferred and placing her on regular probation, giving her an opportunity to stay out of jail and complete the things that she needs to complete.
My concern, my biggest concern and the most aggravating factor I see on all this, aside from the fact that she really hasn't had a fire lit under her to actually start knocking out all these requirements. I'm kind of amazed she did CATSNP and none of the other much quicker and more easy courses. So, I mean, that's plus 10 for her. Just trying to fake a drug test concerns me. Mr. Bain, do you have anything to say about that?
I think the fact that she's on SSI would indicate that she has some emotional difficulties, and her youth and the current environment has probably contributed to her inability. I've just now represented her since August, Your Honor. I think those have contributed to her failure on the probation.
And Judge, the state can see the mitigating factors, seeing that she's on SSI for some type of that, and also the fact that she's at a very young age and it's a trying time for people who are still trying to figure things out.
Okay. Ms. Hicks, the court accepts your plea of true to all conditions on the motion to enter adjudication of guilt and revoke community supervision. I grant the state's motion to revoke your deferred adjudication probation, adjudicate you guilty of the offense of driving while intoxicated first offense, and sentence you to 6 months in the Bexar County Jail. How many more months does she have currently on her probation, Susan? She went on in March.
That's correct, Your Honor.
All right, so let's do 6 months over 6 months, and that kind of keeps us in the same arena for the original time. Mr. Bain, do you think she can get all these other requirements done in 6 months?
I sincerely believe she will try her best, Your Honor, and I don't believe you will have any drug problems or testing problems with her. I think she understands that's the most serious violation on her report.
Okay.
Is that true, Christina?
Yes.
I'm going to assess 48 hours community service, DWI education course, DWI victim impact panel, CASNIP, which you've already done, and you get credit for any monies paid or any programs completed that I continue to order. I'm going to put her on weekly UAs with an understanding when she shows me 4 clean weekly UAs. We're going to take her off of that, put her back on monthly UAs. No more hanging out with your buddies and smoking marijuana, Ms. Hicks. That would be bad. Let's see what else we need to do. What was the initial fine on this case, Susan? Can you tell?
I'm getting that for you right now, Judge.
Your Honor?
Yep.
She has an active warrant.
Well, that'll be recalled by operation of law, but we'll go ahead and formally recall it anyway.
Thank you.
Judge, her fine is $300.
We're going to assess the same fine, $300 for court costs, for any monies paid, community hours served, any programs completed.
Thank you, Pat.
You're welcome.
Susan, what else did I forget?
That's all. Ms. Hicks, do you have a pencil or a piece of paper to write with?
1 second.
Okay. Cecil?
Yes.
She's gonna have to fill out a probation application and a new data sheet. I'm going to send it to her.
Please.
Please tell her to fill out so that it can go to the clerks.
I understand.
Thank you, sir.
And that'll need to be done today.
Yeah, I'm sending that today.
Can I tell her that at the end of the docket? Because that's very important.
Yes, that's fine.
All right, we're recalling the warrant and any prior bond conditions that may have included PPS or SCRAM or anything in that category. All that's going to be recalled at this time. Ms. Hicks, do you have any questions for us?
Yes. I heard that you said you're sentencing me to 6 months, but I also heard I'm staying on probation, so I'm kind of confused.
All right. You were on what we call deferred adjudication probation. If you had successfully completed that probation, your case would have been dismissed.
Okay.
But you violated several areas of your initial probation. So I had the authority to revoke your initial deferred adjudication probation, find you guilty, and just put you in jail for 6 months. But your attorney taught me out of doing that. And instead, we're on regular probation. So you're going from deferred adjudication probation to regular probation, and you now have a conviction for driving while intoxicated. And that's kind of your punishment for your problems in this case. You understand?
Okay.
Your attorney.
Yes, I understand.
So you know, after this hearing is over.
Okay, thank you.
That makes sense?
Yes.
Okay, and you get credit for any monies you paid or any programs you completed. And I could have given you like another 1 year period of time on probation, but you've already done some things. The CASNIP course is the longest course we have, and you've already done that. So good for you on that one. I'm trying to minimize the amount of time you'll be on probation. Continued. So if you don't get everything done in this 6 months, we can extend you, but we would rather not do that. We'd rather you finish it, and Mr. Bain will explain that to you.
Okay, thank you.
Christina, stay on, because Mr. Baines is gonna explain something to you after we're finished, okay?
Yeah, I'm
Okay.
not done with her either, but Judge, she's on Smartwell. She's supposed to be on Smart Start. She needs to get out of lockout. You want that out of lockout within 5 days?
I want her out of lockout within 5 days, and she needs to start at 6 blows a day with the understanding that once she shows me a 30-day period of time at 6 blows a day on the Smart Start mobile device, and we have no alcohol positive violations, and we have no missed tests, I'll crank her back down to 4 blows a day like everybody else.
Okay, all right.
Mr. Banks, explain that to her if that's confusing.
I will, Your Honor. And is it the 6-month probation, was it retroactive to March? Is that what you were asking about?
This is brand new probation right now. She was on deferred adjudication, and now she's on regular probation. So everything's covered for today, but instead of giving her a whole year of probation time, she's already done something, and I think she can get all these other things done in 6 months if she puts her mind to it. So that I'll let fire under her and do that lawyer stuff.
I understand. I wanted to clarify that. Thank you, Judge.
Okay, Miss Hicks,
Yes.
your officer's name is Miss Olmos, O-L-M-O-S,
Okay.
and her telephone number is 335-0416.
Okay.
Miss Benavides is going to send you some paperwork today. You need to fill it out and send it back. And then the probation department will call you or email you or contact you in some way, shape, or form within 48 hours. So if you have not heard from anybody by Thursday morning at 8 o'clock, you need to call the probation department or Miss Olmos and let them know, okay? It's your responsibility.
Okay.
Any questions?
No.
All right, you're good to go.
Thank you, Ms. Hicks. Thank you, Mr. Bain.
Thank you, everybody.
Did we ever hear from Mr. Cole and his attorney on these cases? I never received a waiver of consent.
Your Honor, Mr. Stevenson is here. Yes, he has signed. So Mr. Stevens is here.
Okay, is Mr. Cole here?
Your Honor, Mr. Cole is in my office. Mr. Cole is sitting right there. We're on one phone so that we can avoid feedback, but I can still be with my client to advise him.
Okay, and
I believe we have an agreed recommendation with the state, Your Honor. I just wanted to say that. Go ahead.
All right, let me back up a second. Do we have a document entitled Defendant's Consent to MTR Hearing by Video Conference for Mr. Cole at this time?
No, Your Honor.
No? No?
No.
We both signed. I signed first, and then he signed about an hour ago, Your Honor.
All right.
Signed and submitted.
Let's make this formal then and make sure you clarify that on the record. I'm calling cause 631-312, State of Texas versus Stephen James Cole. This is a second amended motion to enter adjudication of guilt and revoke community supervision.
I'll look, Your Honor.
All right.
Submitted.
As represented by Mr. Ben Stevenson, it's my understanding that the defendant's consent to MTR hearing by video conference has already been executed by both Mr. Cole and Mr. Stevenson. Is that correct, Mr. Cole?
Yes, I have it right here.
Okay. Correct, Mr. Stevenson?
I have done so as well, Your Honor.
All right. Well, I don't have a copy of it or the original.
Your Honor, it is in your email to be signed.
Okay. Well, I'll take care of that then.
Okay, it is there.
The second document I need to bring.
It's there. It's there.
Everybody stop talking. Thank you. The second document I need to bring to your attention is entitled Trial Court Certification of Defendant's Right of Appeal, which should also have been signed by Mr. Cole and Mr. Stevenson. Did y'all sign that document, Mr. Stevenson?
Yes, Your Honor, I did sign it.
Okay, and Mr. Cole, did you sign that document also?
Yes, Your Honor.
All right, all good. Representing the state in this case is Assistant Criminal District Attorney, Mr. Nicholas Maru. Representing the CSED is Ms. Susan Gross, who I remind is still under oath. This is an uncontested motion to revoke probation. My understanding is that the defense and the state have entered into an agreement, and as both parties know I'm not bound to follow that agreement, but I'd be happy to hear what it is that y'all have agreed to. So Mr. Stevenson, would you represent for us what your agreement with the state is on this case?
Your Honor, we are going to plead true to the first two violations on the original motion to revoke. Violation of condition number 2 dated February 21st, 2020. Violation of condition number 15, February 21st, 2020. In return for our plea of true to these, my understanding is the state is going to waive and abandon the other alleged violations and is going to recommend, along with us, that the court alter and amend conditions so that my client is required to test with Smart Start 6 times a day until the court is satisfied that he does not need to test that often.
Okay, state, is that your understanding of your agreement with Mr. Stevenson?
Yes, Judge.
Let's formally go on the record and on cause number 631312 on the second amended motion to enter adjudication of guilt. It's my understanding that Mr. Cole is going to enter a plea of true with an explanation to condition 2 and condition 15. Is that correct, Mr. Stevenson?
That's correct, although there's not really a great explanation for these two.
Okay. And 15 BAC. All right. The other allegations that we're not going to take up, my concern is this obstructing a camera business on the Smart Start Mobile. Is that going to continue, or do you think we can figure that out and make sure that doesn't happen
That
anymore?
was a, so Judge. Oh, go ahead.
I've
Go ahead.
spoken with my client. My client understands that there is both a light source on the camera built into the camera and a lens. My client has never seen one of these pictures that he is taking as he blows into the machine, and he was not aware that he has been covering it sometimes. He assures me he's never been trying to obscure it and would have no reason to try to obscure it. But now that he knows there's a problem, he will get educated on how not to hold it so he doesn't do it again. This has not been brought to his attention in the past, apparently, Your Honor.
Okay.
I also did want to speak on the circumstance, very briefly, on the circumstances of the two violations that we pled true to, Your Honor.
Sure, go ahead.
In a nutshell, my client had need for the rehabilitative programs and structure that probation offers. And 3 days after his probation started was when he got his handheld device. It was also a time when he really needed those programs and that structure. So the fact that he immediately tested positive is simply evidence that he needs the rehabilitation and the structure and the accountability that probation provides. And he has no defense for those positives, only that he is not proud of that and he needed the help.
Okay, and what, apparently he's already done all his programs, Susan, is that correct?
Judge, if I may, yes, he has completed DWI education, victim impact panel, and CAT-SNP. We do not have any proof of any of his 48 hours community service having been done. He has paid $766 towards his fee, has a balance of $720 and is delinquent $60. His reporting has been good. We saw him last on October 14th of this year. He has had 3 positives, one for marijuana, and of course the 2 alcohols on the Smart Start mobile device. He did have 1 diluted drug test, but he has also had 5 negative drug tests. We are recommending that his Smart Start be increased to 6 times a day and that he shows substantial compliance within 30 days. And his only prior arrest is a possession of marijuana.
Okay, Mr. Cole, the court accepts your plea of true with an explanation of condition 2 and 15 on the motion to enter adjudication of guilt and revoke community supervision. I deny the state's motion to enter adjudication of guilt and revoke your community supervision. Order you continued on deferred adjudication probation with all prior requirements and no sanctions this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, sir?
No, Your Honor, will not. And I do believe when I was using the Smart Start, I was kind of trying to block out some light, and I believe that's where my thumb was getting in the way. I will make sure that
okay.
Fix that.
We're going to alter and amend the conditions of his probation and modify his Smart Start mobile within 24 hours for 6 blows a day. Once he shows me, Ben, a 30-day period of time where he hadn't missed any test at 6 blows a day and there are no high bracs for alcohol, I'll crank him back down to 4 blows a day.
Excellent. Thank you, Your Honor.
On weekly UAs, once he shows me 4 clean weekly UAs in a row, we'll take him off of that and put him back on monthly UA.
Thank you, Your Honor.
Mr. Cole, we test you today. You're going to be positive for marijuana again?
Are you going to be positive for marijuana if tested today?
Your Honor.
Yes or no? I'm sorry, I missed it.
No, Your Honor.
All right, good answer. Put him on weekly UAs and we'll see where that goes. And Susan, what did I miss? I think that pretty much covers it, does it not?
That'll do it, Your Honor. Mr. Cole, you're going to be receiving amended conditions from your officer within the next 24 hours electronically. You need to sign those and send them back. If for some reason you do not hear from your officer, you need to call her. It is on you to get this document signed.
Okay, yes, ma'am.
All right.
Okay.
Your Honor, he has an active warrant.
We're going to recall warrant. All
Thank
this
you.
accomplished by operation of law, just by us having this hearing, but someone doesn't understand that. We're going to formally recall the warrants. Any aggravating factors of bond like GPS or scram, stuff like that I may have ordered, I'm recalling. So we'll make sure that all comes back.
Your Honor, may I ask if it's related to this case?
Sure.
Okay. I just want to make sure there was no other case out there that none of us knew about.
No, I think Mr. Cole's been good in all other areas. Either that or we haven't caught him yet. I'm not sure how that works exactly.
I think you were right the first time, Your Honor. Thank you.
But he's got good lawyers if he does get caught, so we're all good.
Yeah. Do my best.
Anything further from the state or the defense on Mr. Cole?
No, Judge.
All right.
Nothing further from defense.
Thank you, Mr. Stevenson, Yard and Smith.
Thank you. Back out.
Okay, I've now got, and this, cause number 61088, State of Texas versus Michael William Agnew. Representing Mr. Agnew, Mr. Johnny Cisneros, attorney at law. In this case, as in all cases we hear today, representing the state is Assistant Criminal District Attorney, Mr. Nicholas Maru. Representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. This is a motion to revoke community supervision. It is uncontested. I'm holding in front of Mr. Agnew and Mr. Cisneros 2 documents. One entitled Defendant's Consent MTR Hearing by Video Conference that purports to have both their signatures at the bottom. Is this your signature on this document, Mr. Agnew?
Yes, sir.
Mr. Cisneros, will this be your signature on this document, sir?
It is, Your Honor.
And Ms. Benavides, for my copy of this document does not have a cause number at the top. So if that is not filled out on the original one, that needs to be filled in.
Okay.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And Ms. Benavides, once again, there's no cause number at the top of the copy of the document I have. There may be one on the original. This document also purports to be signed by both Mr. Agnew and Mr. Cisneros. Mr. Agnew, is this your signature on this document, sir?
Yes, sir.
Mr. Cisneros, is this your signature on this document?
It is, Your Honor.
And I also noticed we're in the style of the case at the top of the Trial Court Certification of Defendant's Right of Appeal. County Court at law number, and 6 is not in there, so that needs to be added to the original document.
Yes, Your Honor.
Okay. And on the motion to revoke community supervision for Mr. Agnew, how does Mr. Agnew plead?
We're going to plead true with an explanation, Your Honor.
Fair enough. Ms. Gross, what's the status of Mr. Agnew's probation, please?
Judge, Mr. Agnew has been reporting as directed. We last saw him on October 13th of 2020. He's paid $902 towards his fees. He has a balance of $534 and he is delinquent $400. We have no proof of completion of any 36 hours of community service. He has completed DWI education, victim impact panel. He was ordered to do the CAPSNP program, but he did the intensive outpatient program on his felony case, and you agreed to give him credit for CAPSNP in lieu. He has had 5 positive drug tests, but they were all positives with a valid prescription. He's had 3 negatives and 1 failure to submit. He is currently on Smart Start Mobile testing 6 times a day. He's had 9 skips and 1 high BRAC that occurred on September 27th of 2020 at 5:01 a.m. And he tested at a 0.024 and he failed to provide a retest. His officer is recommending that he remain on the Smart Start mobile device through the term of his probation, which would be until January the 5th of 2021. His prior arrests include theft 500 to 1,500, assault bodily injury, criminal mischief 750 to 2,500, possession of a controlled substance, penalty group 1, less than 1 gram, and a felony retaliation in which he's currently on felony probation 4.
How long has Mr. Agnew been on the Smart Start mobile at 6 blows a day, if you can tell?
Let me look for you.
Mr. Agnew may know better than you. He can tell us if he knows. Do you remember how long ago we cranked up your Smart Start, sir?
I want to say about a month and a
September
half ago.
17th.
Yep.
I'm sorry, go ahead, Mr. Agnew.
I believe about a month and a half ago.
Okay.
Judge, it was September 17th.
Okay. And we haven't had a substantial number of skips during that time frame, or have we?
9 and a high BRAC.
1 high BRAC and 9 skips.
Judge, but he had problems with the Smart Start device to the point where he had to be recalibrated, and in fact they changed the device on him, and I don't know how that goes. In all honesty, he should have been off the Smart Start since July of this year, and it was extended, and we're asking that it be removed. And he, as was discussed, his probation expires January the 5th of 2021, which is what, a couple of months.
Well, we only take the Smart Start off when probationers have been good and not drinking. Unfortunately, in Mr. Agnew's case, he apparently had prior violations when I cranked him up from 4 blows a day to 6, and now we still got a violation that's plus alcohol.
Well,
So
one of the violation that we're talking about, if I'm not mistaken on the date, Your Honor, he went to take the test. Now, I may be confused. I don't want to lie to the court. Ms. Gross can tell us better, but there was one time that he waited 4 hours to take the test, and he had to leave, and he came out positive because he didn't take the test that day. He had to leave. He waited 4 hours to take the test. They all took off to lunch and whatever happened, but you know, he wasn't dirty that day, you know. So I'm just saying that he should have been off in July, and we're asking that the court remove the Smart Start.
the test you were just referencing, is that a urinalysis test he waited 4 hours for? Not a Smart Start mobile blow in the machine test, a urinalysis test where you had to go down to the.
That's what it was. I'm sorry. Yes, sir.
I'm worried about the Smart Start mobile. He must have had a violation for me to crank him up to 6 blows a day.
Well, and that's what we're talking about, that he's had problems, Your Honor, with the Smart Start device where it had to be recalibrated and they changed it.
So anyway, here's the point. If he's willing, you know, if we haven't missed too many blows, we're not going to miss any more blows. Everything starts over today, so to speak.
Okay.
If Mr. Agnew doesn't miss any blows, and he shows me 30 days at 6 blows a day without missing any blows and no high BRACs for alcohol again, we'll crank him back down to 4. He only has 2 months left on probation. We all agree, right?
That's
Yes,
correct.
Judge.
You can just stay away from light beer from Miller for a couple of months. We'll be good. Okay with you, Mr. Agnew?
That works.
Yeah, I bet it does. All right. Dave, you got any further input for us before I rule?
No, Judge, I'm along with probation.
All right, fair enough. Mr. Agnew, the court accepts your plea of true to all conditions on the motion to revoke community supervision with an explanation. I deny the state's motion to revoke your community supervision, or you continued on community supervision with no sanction at this time, continuing your Smart Start mobile device at 6 blows a day, with the understanding that once you show me a 30-day period of time at 6 blows a day on the Smart Start mobile device, without any positives for alcohol, without missing any tests, I'll crank you back down to 4 blows a day like everybody else. I will not know you've done that. If you do that, let your lawyer know. He'll let us know. We'll confirm that that's true, and I just make a phone call, and that gets changed back to 4. I'm going to put you on weekly UAs. From the standpoint, you show me 4 clean weekly UAs. That's half your probation period left. I'll take you off of that, and we don't have to worry about that anymore. He's done everything else, has he not, Susan, except for money?
He has a balance of 400, and he still owes us 36 hours of community service.
Okay. Needs to either do the community service hours, we can donate $10 an hour to a court charity, which are primarily wounded warrior organizations and family violence prevention organizations, and SAPD 100 Club for the families of the officer killed in the line of duty, that kind of stuff. So I'll let Mr. Cisneros talk about that with you. But once he gets up to the end of his time, I mean, we only have 2 months left. He needs to start knocking this stuff out so we can terminate him SAT when he gets there. Further from you, Mr. Cisneros?
Well, I know how it works, but just for the record, he does have a warrant, so I know it's going to be closed out.
We're going to recall any bond conditions that we may have added early on for the MTR. So
Okay.
if he's been under a SCRAM order, or he's been under a GPS order, those will all be taken back.
Okay, and Your Honor, I know that off this case, Mr. Floyd Rivera's on standby on a case. He's probably taking a nap right now, but if you can't reach him because he's asleep, let me know. I live close to him. I'll go wake him up.
Don't listen to him, Judge.
Just wrong. Just wrong.
Oh, my buddy, Johnny.
We be excused.
I think he's out letting your tires on your car, Mr. Cisneros, if I were a guest.
Thank you all. Bubba, y'all stay safe.
All right, Mr. Agnew, you're going to be receiving a document from your probation officer within the next 24 hours. It'll probably be tomorrow. Okay, you need to electronically sign it and send it back to her. It's on you to make sure that that gets done, okay?
Yes, ma'am.
From her within 24 hours, you need to call her tomorrow, like at 4 o'clock, and say, hey, where's my paperwork, okay?
Yes, ma'am.
You have any questions?
No.
All right, good luck to you. Don't come back.
Yep.
Thank you all. Everybody stay safe. Bye-bye.
You too.
All right, last but not least, we have case number 624727, style state of Texas versus Stephanie Garza Paez. This is a motion to go.
Excuse me, Judge.
Guilt and revoke community supervision. Representing the defendants, Mr. Attorney Floyd Rivera. Representing the state is Assistant Criminal District Attorney Nicholas Maru. Representing the Bexar County CSCD is Ms. Susan Gross, who our mind is still under oath. This is an uncontested motion to revoke probation.
Excuse me, Judge.
Yeah, go ahead.
Judge, before we start, I have to take up one important issue with Mr. Maru. It'll take me about 2 minutes.
Yeah, do y'all need to go in a chat room?
Yes, it's real short, Judge.
Take your time. We got plenty of time. Go ahead.
Appreciate it, Judge.
You are in 3, Mr. Rivera. I will put Nicholas in 3 as well.
Okay, I appreciate it. It won't take me long at all.
Can you put Mr. Cisneros and Mr. Rivera in the same room and let them fight? I think that'd be good.
Room 3.
Oh, Johnny's crazy.
Thank you.
And we
You
got
can go, Mr. Rivera.
Yes, ma'am.
You can go.
Okay, let me see.
Join 3.
Oh,
It should be room 3.
Okay.
Okay, bye-bye. Okay.
I'm here.
All right, Susan,
Hey,
your
Sue.
guy is in the breakout room at this time.
I don't need to talk to him. I need to talk to the person in charge.
Good luck with that one.
All right. Yeah, me and Bess have been talking a lot, so I'm all on the same page with him. Are we on you? Yeah, see, I'm not comfortable doing this live on YouTube. So
Judge, Suzanne would like to go in a breakout room with you.
I've gone into breakout rooms with judges before.
Yeah, would you go in a breakout room with Suzanne?
Why do we need to go to a breakout room? What are we hiding from everybody?
I'm not hiding anything. I'm happy if Susan Gross joins us in the breakout room. I'm just not real thrilled about putting all of this out live on YouTube when it's not part of the actual